So, what to replace copyright law with? Since I oppose copyright law, especially in its current form, but not necessarily anything that could be something like copyright in concept, then the question is, well, what kind of a copyright law would I support? What kind of a copyright law would I implement in case the current one was changed or removed or had to be replaced? Well, let's get into it. First of all, I wouldn't make any amendments or changes to an existing copyright law because, well, it's the starting point is already so far, it is already so bad that it's just useless. So first I would just eradicate everything related to copyright, just all of it, just gone, start from zero, and I would just implement a completely new system that is entirely different. So get rid of everything that existed as copyright in the past. And by copyright law, what laws do I specifically refer to? Because countries are different with different laws. Well, mainly something like USA and EU, because those are the ones that I'm familiar with. And the ones that mostly matter. Oh, who cares? Anyway. So the laws of like the EU and USA, those are the types of copyright laws. So, well, it doesn't really matter because, well, I would eradicate all of it. So anyway, let's get to the new laws that I would implement. Well, first of all, there would be 3 different distinct categories that works would go under that would currently all be under the same copyright law. So these would be 3 distinct separate laws that are different categories independent of each other. So I wouldn't replace the entire copyright law with a new other copyright law. No, I would basically split it up into 3 different categories of laws that are independent of each other entirely. So there wouldn't be a copyright. There would be like 3 replacements for copyright. So let's get to the first category. The first category would be the sort of artistic works category. This contains all the most obviously like paintings and whatever, but it also contains all the other works that are artistic in nature, where they're like fictional writings and all kinds of movies that show all these fantasy worlds and whatever. Anything that's even remotely artistic. Now, there needs to be specific terminologies and specific definitions, because edge cases might become difficult if there are not very specifics. If there are no specifics. I'm not sure how in depth I will go in this speech, but I will probably give a more overall overview of these laws and not some very specific. I can do that sort of a specific thing, but I just don't think I'm gonna do it now. But anyway, so yeah, I don't know how specific I'm gonna explain the laws, but I'll probably go with the overall overview. So, this time. So, the artistic works, they are things like works that would be artistic in nature, which means that they are fictional, or if it's a movie, there are actors that are portraying fictional characters, so like they are not being themselves, they are playing a role, fictional, and all kinds of artistic works that have, well, in case of, let's say, paintings, they are like, there's paintings, and well, basically all paintings, I guess, that are like, they depict whatever, the generic idea of a painting, basically, that has like stuff, that it's not some sort of a technical drawing or a blueprint, it's like a painting, a distinction like that should be defined. What counts as a painting and all that stuff, so like, it has to be, or music also, music is all basically artistic and all that stuff. So those artistic types, they are distinct from things that are functional works or political speeches, which are the 2 different categories, the 2 other categories. So the other categories are those 2. I'm gonna get into them later. So in the first category, what would the laws look like? Well, the author of a work should probably retain retain an exclusive monetary right to the work, so that they are the only ones allowed to make profit. But anyone can make their own. Anyone can basically. Well, yeah. Let's just start with this one. Let's say there's an artwork, let's say movie, and the movie portrays characters and events that take place. So I think it should be allowed that people can make versions of, no, not versions, derivatives of that work that are like sequels and prequels and such things, spin-offs, things like that are not the exact original work, but they reference events and characters' likenesses and things like that took place in the original work. That should be allowed, and those things would not be the original work anymore. They would be a different work. It just has similar characters and whatever. So only the original work is the one that any of the exclusivities would apply to, basically. But I'm not so sure actually how far that should be expanded. How different should it be, some derivative work, until the creator of that work can also profit of the work. I'm not still sure how far it has to be, how different. Obviously, the closer it is to the original author's work, the more exclusive the author's rights should be to that work, and yeah, so the further more original it gets from another author, the more they should have the right to that. So yeah, if it's a very, very different story, entirely different, well then obviously the original author shouldn't have any right to it. But if it's very similar, it's almost the same, but it's just slightly different, well then the original author should retain some sort of a monetary exclusive right to it, because, well, it's mostly the same, but it's just slightly different. So there should be like, I don't know if it should be like some sort of a gradient, or maybe there should be like some sort of a threshold set at an arbitrary point, or maybe there could be a couple different levels, a few different levels of like the further some derivative gets from the original work, like the less rights the original author has to that work. There could be some specifics like that. I'm not so sure on that specifically yet. But yeah, that's something that should be done, that there should be some sort of a monetary exclusive right. But then, let's get to the next thing on the same artistic work still. Sharing, which is like the whole point of the current copyright laws, that they prohibit sharing and distribution of the files, or in case of digital files on a computer, most evidently these days, people don't really much distribute physical copies of DVDs anymore these days, which would have been the biggest issue at the time when that was a thing. Anyway, the biggest pressing issue of copyright these days is on the people that like the sharing of files is bad, or I mean illegal. According to the copyright, it is bad. Of course, it's not morally bad, but it's like according to the laws it is. But the laws are wrong, which is why I want to replace them, which is what this speech is about. Anyway, sharing is good. So if you're sharing with your friends and want to give copies to your friends in private, that's reasonable and that can be done. In fact, anything in private can be done. So if you keep it to yourself, you can do absolutely anything you want. You can make all the derivatives and all the modifications, and you can make all the millions of copies of the work. You can do absolutely anything you want in private. So no laws should restrict anything you do in private in any way, shape or form. There should be no laws touching what you do in private. You can do whatever you want. So that's important. So all of these exclusive monetary things and all that, they should only apply to public distributions and such things. So if you make some of those your personal things that you've made, some sort of derivatives, if you make them public, only then do those exclusive monetary things and whatever laws apply. So in private you can do whatever you want. And also, in private with other people, so long as it's in private, you can also share files and do whatever you want. So, I'm thinking that like, perhaps, I'm not so sure on this, but I'm pretty sure, I'm thinking about this, and I think it's a good idea. that perhaps it should be somehow discouraged that like exact copies of the original work are like publicized like in a way that competes with the original author's publication, because, well, it's kind of that original author's work and they are the ones publicizing it, so it's kind of weird if someone else takes that and also publicizes it. So that's kind of weird. So there should be some sort of a way to discourage that. Like, it is sort of a big-ass public thing. Now, in private, you can do whatever you want. So it's important to realize the difference between distributing copies to your friends in private versus publicizing a work and doing marketing and like distributing copies to like stores that sell copies. Like there's a difference between those two. So that distinction has to be made. In private with your friends, you can share files and you can do whatever you want. But if you make this big distribution out there in the public, that's a different thing. So that should be more restricted, and perhaps I don't exactly know what should be done with it. Should there be some sort of a punishment or whatever? Those are specifics that need to be thought about later. But that's the general idea, the overview. Something that should be thought about, like something like that. And then, what haven't I talked about yet? So let's see. Distribution with friends, distribution with public, derivative works. Well, yeah. Basically, that's about it for like the artistic law that would replace it. Well, basically, for the most part, this artistic law thing, it would just give the original author an exclusive right to monetary profits for the original work. And they further away some derivative work, whether a spin-off or like some sort of a fan sequel, fan film type, fan art or fan fiction, all kinds of things like that. Well, most obviously they should be allowed. So that's the first big key difference between the current copyright laws and my proposal for a copyright law replacement. Is that like derivative works should be allowed. Like, first of all, they can be made, and there should be no restriction on making them. Like the only thing that would be the thing is that like there should be this exclusive monetary profit thing. So the further away the derivative goes from the original, the less of a right the original author has to that work. So and then there's the distribution in private with friends. That should be allowed. So the current copyright laws, they prohibit all kinds of copying and sharing in any form, in any context. But I think the context is important, because sharing with your friends in private is different from sharing publicly in some public way and all that stuff. So those are two different things that should be distinct, and one is perfectly reasonable and the other should be less so, and there should be all kinds of, well, obviously there is the monetary exclusivity for the original author, so that would probably discourage others from making also public works, publicizing the same work in a weird way like that. Because I think that's really weird. If you make a movie and you distribute that movie and you publicize it, and then someone else takes that same movie and publicizes it and like competes against you, that's really weird. So there should be, well, most obviously the monetary exclusivity. So that itself would already discourage others from doing that, because there's no point. But perhaps there should be like some sort of a, like more sort of punishment or something, a fine or whatever, that would like restrict how that can be done. Or maybe it just should be outright forbidden to make this sort of a big publication of an existing work. You can keep distributing among your friends, amongst yourself with your friends. You can keep doing that, but this sort of big publication, like there should be a distinction between those. So yeah, now I'm just repeating myself, so let's get to the next point, or next category I mean. So the next category, the second category of these laws that would replace the copyright law, out of the 3 categories. The next category, the second category, would be the political speeches and statements of opinion types. So if you make a recording of yourself and you make some sort of a political statement, or you express your views and opinions and viewpoints and whatever, you comment on some political issues or whatever, actually much like whatever I'm doing right now. Yeah, exactly what I'm doing right now. This recording is a good example of what would be that second category, political speeches, and I don't know what to call it. Really, the names are arbitrary. Who cares what it's called? It's the category that includes all these sorts of, let's see, well, this speech, for example, and things that are like, well, if you give a presentation in front of an audience and someone makes a recording out of that, well, that belongs in this second category. Let's see. Well, all kinds of commentating style things that are like done on some sort of a political issue. I guess news programming, yes, news programming, and that is like depicting events that take place in the world. So sort of these sort of journalistic types and reporting things, these sorts of things that are based on factual, that are either based on factual real world things like news programming and journalism and newspaper style stuff. So either that or just statements of opinion. So things like where someone shares their political views and makes a speech recording out of them or something. It doesn't have to be a speech, obviously. It could be a camera video with audio and all that stuff. Yeah, the specific media is not too important. The nature of the media is the important thing. So things where someone is sharing. So yeah, there are these two different things, 2 different types that belong in this same category. So those I mentioned. So the one type is those things based on in the factual real world things like the news reporting, and this political personal views type one. There are 2 different types, but they belong in the same category. So it doesn't have, see, here's the thing, it doesn't have to be factual necessarily in nature, whereas like where the one category with the news reporting, it has to be based on like actual factual events that take place in the world if you're making journalism and all that kinds of stuff like that. But also, it doesn't have to be necessarily like true, as in factually true, because, well, obviously people will make mistakes, and also, well, if there is a clause that requires that it has to be based on something that actually truly happened with like evidence, well, who gets to decide that? Yeah, who gets to decide that? Having a clause like that would be really dangerous and it would be a really big mistake. Do not add a clause that requires it to be actually based on truth. Because who gets to decide truth? Because I'm talking about a legal system, a law that replaces copyright. So if you put in there that you are only allowed to like publish things that are based on truth, well, who gets to be the truth police? Yeah, that's really dangerous. Don't do that. It doesn't have to be based on truth. It has to be based on facts, like information. You know, statements of opinion also belong in this category. Something where someone reports on things that the way they see it, you know, that yeah. So there will be no truth police. That's a really bad idea. And that's like very totalitarian and that's evil. Yeah. That should be absolutely avoided. So things that are in their nature, like presenting things, presenting events that take place in the world, whether accurately or not, presenting things that happen in the world, or sharing your political views and opinions, your opinion on some political event, or it doesn't have to be necessarily political either. It could be really anything that's like a statement of opinion, like anything that, like, well, it's not like it can't really be called art. You cannot really call this art that I'm doing right now. I'm not really doing art. This doesn't belong in the art category. So anything that's like this sort of statement of opinion style, yeah, they should belong in this second category. So I'm not going to repeat myself anymore now, so I'm going to explain how the things would work. how the law would work. How does it affect the people? Well, first of all, again, sharing should be allowed. So sharing copies of the speeches and whatever they are, that's allowed. But this time there is a key difference compared to the artistic category. This time derivative works are not allowed. They are forbidden. You are not allowed to make derivative works out of political views and statements and all that, because a speech recording that records someone's viewpoint and statements of opinion, that's their viewpoint, their statement of their opinion. You don't get to change that and put words into someone's mouth. So that should be forbidden, to make derivatives out of political statements and these sorts of news programming, journalism types and all that stuff. So you are not allowed to take them, make modifications and redistribute those modified versions. That should be illegal. Because there's really no reason to. Like, in case of artistic works, that's culture, that's art. People build on art and like they take art and modify it and make other art, and like that's how art is made. So that's art. But with political speeches, you don't take someone's political speech, then modify it and publish it. Like that's just putting words into someone's mouth. So that's not the same. So it's crucial to understand the difference between these different categories of these laws. This is why I have 3 different categories, because they are entirely different. Political statements are not art, so they shouldn't be under the same law that art is. You know, the current copyright system really is stupid. Like, it's not only evil and morally wrong, but it's also stupid. Like, it's just stupid. Anyway, there should be 3 different categories. Or maybe it's not really stupid, it's just evil. It's purposefully bad. Like, it's purposefully designed to be stupid in a way that's like harming the people. So perhaps it's not necessarily stupid, perhaps it's really just evil. Well, who cares? That's just my opinion on the current copyright laws. But anyway, get back to my ideal copyright replacement legal system. Anyway, so derivative works are not allowed. And now, I'm not sure what to do on these sorts of monetary exclusivity things with this one, because, well, I guess it could be sort of similar to the artistic work type situation, but this time there are no derivative works. So, having an exclusive right to the monetary profits would only apply to that specific recording, because there are no other derivatives of that recording. Some political speech or anything. I'm just using the recording just as a placeholder. It doesn't have to be it doesn't have to be a speech recording. It can be a newspaper or a video recording or whatever. I'm just using the word recording just as a placeholder to refer to this. Whatever. So there would only be that one thing, the recording, that one specific exact original form, because, well, in case some derived form does pop up somewhere, someone makes some derived version, well, that's just illegal and it should be banned. So we don't need to be concerned with what to do with those other than to just get rid of them. But, well, of course, also it's important to realize that when I'm saying that they should be gotten rid of, I don't want to implement some sort of a draconian punishment system where people are put in prison for years if they make some break some small law, but like it should still be illegal and there should probably be some sort of a fine and it needs to be taken down, because, well, you're putting words into someone's mouth. If someone makes a speech, some political speech, you shouldn't change that. That's their speech. Make your own speech, then you get to have your copyright replacement law apply to that. Yeah, so there's no reason to make derivatives of political things. Well, let's see, on the sharing thing, are you allowed to share? Well, I guess that would basically be the same as for the artistic laws. In private you can do whatever you want, you can share. Yeah, also in private you can make derivatives. Again, in private, in your own home, you can do whatever you want. So even with political speeches, you can take someone's political speech and modify it and do whatever you want with it in your own privacy, because it's your like privacy. It's no one else's business what you do in your personal life, as long as you don't take it anywhere else. You can do absolutely anything you want. You can take someone's speech recording and you can modify them. You can modify it so that they said something else that they didn't. That's perfectly reasonable if you do it in private. That's your personal business. So anything goes. That's important to realize, that in all of these 3 categories, actually, even in the 3rd category, anything goes in private. You can do whatever you want. But then, let's see. Well, I guess it would be more or less the same for as compared to the artistic system. Well, then should I say a couple things about the differences between the artistic and political categories? Well, apart from the ones that I've already mentioned, what actually makes a work qualify as an artistic work? Or, let's talk about that one some. Let's see. So, let's say someone makes a video recording with audio also, and there is someone standing in front of the camera, and they do stuff. So what makes that recording count either as an artistic work or a political work? Where's the line? Where is it drawn? What's the difference? Well, there are a few specific things to look for. Is the person in front of the camera portraying a character, a fictional character, someone who is not themselves, like they are not playing themselves, they are not stating their own opinions, they are portraying a character? Well, if they are portraying a character, then that's fiction, that's no longer a political speech. So that's basically a difference in that case. If you are actually speaking as yourself, you are speaking your political views, then it qualifies as a political speech. But if you are portraying a role, playing a character, you are an actor, then that's a fictional artistic work. So the differentiating factor there is that one is based on a truth, some sort of a true thing in the world, like your true views, that are actually real. Real. They are your real views. They are not fiction. So that's the fiction element is the important thing. But then this may become difficult. There are edge cases with things like documentaries. If you make a documentary, you might have some sort of actor portraying some sort of a role, where he portrays some sort of a historic figure. There are edge cases where it becomes difficult. If you have a documentary where someone plays the role of some political person in the past, that's pretty difficult to decide then. Should that qualify as art because they are presenting their artistic interpretation of history or something like that? Or should it qualify as being a political work because they are stating their political views? Well, that's an edge case that has to be defined. Basically, well, either way, you just slap on a rule and you just set a threshold. You just set that this one isn't and this one is not. So you basically just have to set the rule. You just put it somewhere. So basically, just decide. So what would I decide in this case? Well, I'd say that the documentary counts as a fictional work because, well, it's kind of arbitrary, You can decide either way, I guess. You could see that as a political speech, but it has to be consistent. It has to be actually written in the law. It cannot be done in case-by-case basis. It has to be actually in the law. So when you are implementing this law, you have to define it there, that this is a political speech and this is artistic. You have to define it there. So it can't be in a case-by-case basis because that just becomes a blurry mess and that's just difficult and it's inconsistent and it just becomes a problem. It really just becomes a problem when it's unclear. It has to be well defined in the law. So, if you are going to implement this law, then just pick one. Pick one and stick with it. People can still make, of course, political speeches. Just drop the actors. Just have some dude explain the history in front of a camera. That's still a political speech. It doesn't really... I would make it a fiction. I would make it an artistic work. I would do that But I guess I could see the point if someone wanted to make that a historic statement, but I would make it artistic work because, you do portray actors playing fictional roles and whatever. Even if they are based on historic works, they are still like fictional interpretations. That's not the actual actor. No, that's not the actual person. It's an actor playing that person, right? So I would say that's artistic. So that's the way I would do it. I can see the argument other way, but I'm not gonna go with that one. I'm gonna say that it's artistic because, well, if you make an act, see, here's the thing. Here's the differentiating thing that I say is good. Here's the reason why I would pick the artistic work, because, well, if you have a camera record an actual political figure giving a speech, well, then that's political speech. But if you have an actor portray a role of that political figure, well, now that's artistic because they are an actor playing that role. They are not being that real actor. It's not based on real life. It's actors. It's fiction. Yeah. So that's the differentiating factor. That's the way I would do it. And I think it's the better way to do it, actually. Yeah, that's what I would... Actually, yeah. When I talked about the other way of doing that, seeing that as sort of a historic political statement, well, no, not really. Actually, yeah, don't do that. So yeah, don't make that into the second category. The second category is only exclusively for those things that are, yeah, it's better this way. I decided, yeah, I've come to a decision. It has to be this way. Yeah, I not only think it's better the way I would do it, no, I actually think that's the way it should be done. Yeah, so you should do that also if you implement this law. Yeah, so just forget about making documentaries based on, forget making documentaries go under the second category. They are not political, they are artistic. So yeah, documentaries are artistic. You have to portray the actual physical person giving a speech for it to be political. If you portray a historic figure who has already died a long time ago, you have some actor portraying the role, well, that's fiction. So yeah, you just set a hard line like that. So there may come across some sort of edge cases like this where it's difficult to decide. Well, in other cases, we'll just pick one. Yeah, this is just an example. So I'm not gonna talk about every possible edge case that might be possible because, well, first of all, I need to think of it first, and I can't think of any others right now, or rather, I don't really care to do so. I might be able to if I wanted to, but I don't really care to do that now, so I'm not going to. But that example is enough to illustrate my point. So let's move forward. Should I get to the third category, or is there still something I have to say about this? Let's see. Political speeches, differences between art and politics. Let me think. Let's see. What have I already said? Let's see. Copyright law in its current state restricts the use. Yeah, I guess I could mention, should it be allowed to publish, like, well, actually, nah, it's the same as the artistic, so there should be some sort of a restriction, something discouraging the publication of someone else's political speeches, yeah. It should be the same as for the artwork, yeah. So apart from those differences that I've now talked about, yeah, they should be pretty similar. So yeah. Okay, let's move on to the third category. The third category, the final third category that replaces the copyright law along with the two other categories. And that one, the third category, is the functional works category. Now this is the category that includes all the things that are, all the works that would currently go under copyright that are practical in nature. They have some sort of a practical purpose and they are meant to do work and stuff like that. So examples would be something like computer software. Computer software is work that is done to do real work. Like the computer software as a copyrightable work is meant to do real work in the real world. It's a practical there is a practical use case for software. You run it and you do things with it. So it's not something you just watch for the sake of watching it, like how art is. If you're looking at a painting, then you don't do anything with the painting. You don't do work with the painting. You don't use the painting to do stuff. You just look at it. So the difference between the third category and the first category would be that difference of work. So do you use the thing to do work? So computer software is an excellent example of this. Computer software is obviously used to do work. It is software that you use to do things. So it should go under the third category that replaces copyright law. And remember, these are three distinct laws. They are not categories of the same law. They are entirely different laws. So what used to be copyright no longer exists. It has been entirely eradicated. All the remnants of it has been eradicated. There's no copyright. And in its place, I implement three distinct separate laws that are independent of each other. They are not under the same grand law. No. They are three different laws that have nothing to do with each other. Independent, entirely different. Not even remotely similar. They are not a part of the same bigger law or anything, or different categories of the same law or anything. No. They are entirely different. Different laws, entirely different purposes, different effects in the world. Nothing to do with each other. So, the third category of things that replaces copyright is the functional works category. And so, what should this one do? Well, in this category, I would implement, well, in case of computer software, something that's called software freedom. So, free as in freedom respecting software. So, the software respects the computer user's freedom. So, in case of software specifically, the software should be distributed to the users with the source code. So, basically, expanding this to other things also that go under this third category. It shouldn't really be called the source code. It's the preferred form for modifications. Yeah, let's call it that. The preferred form for modification, that should be made available to the people. So, in case you write a computer program and you distribute that program to the people, you have to make the source code, in case of computer software, but rather the preferred form of modification, preferred form for modification, you have to make the preferred form for modification available. So, in case of computer software specifically, the source code. You can't keep the source code private. You have to make it public. You can distribute binary-only distributions of the software, but the source code has to be available. It doesn't necessarily need to be included in the specific distribution, but it has to be available. It has to be made public, basically. So, functional works, because they are used by the people to do things, real work, they belong to the people in such a way as allowing them to do whatever they want with that work. So in case of computer software, but it includes other things. Well, actually, let me give other examples, because I haven't given any others yet. Along with computer software, other technical things that are used to do work, let's say some sort of schematics and blueprints and 3D printer model things and all kinds of things that are like used to do work. So it doesn't have to be specifically computer software, but computer software is just the good example. It's really the primary example, but the law applies to those other things that are also practically useful, that are actually used to do things. So yeah, I'm just going to use the computer software as an example because it's the best example. So the software belongs to the people, and they should have the right to do whatever they want with the software and control the software. This is the important thing. They should have the control over the software, because if you run software on your computer, it is your computer, and it should be your right to control the software. So the software that you run, you should be in control of it in every way possible, because, well, under the current copyright law system, the copyright holder of the software, they have the power over you, the user. If you use computer software and it's proprietary software, that proprietor has all the power over you. They control what you do. They have the legal authority to do whatever they want, not you. So you, in your life, in your personal life, you use software to do your work, and someone else has control over your life, because they have control over that software. So if you're using software to do things in your life, and someone else controls that software, they control your life now, and that's really bad. So you should have the absolute freedom to do whatever you want with the software, and the software source code has to be made publicly available. The preferred form for modification, whatever that may be in the case of other things that are not software. For technical works, for functional works, the preferred form for modification has to be made available, because they are works that are used by the person to do work in their life. That's actual work they do physically or digitally on the computer, but work all the same. They do work. There's a job to be done, and there needs to be an absolute control over it. Because, well, here's the thing. Let's compare it to the physical world. If you have a hammer in the real world, a physical hammer, and you're hitting nails, well, it should be your right to hit the nails however you want, without someone physically controlling that hammer. Like just think of it this way. What if the current copyright law restricted your use of a physical hammer the same way it restricts your use of computer software? Like, how stupid would that be? There would be licenses on how you are allowed to use a hammer to hit nails. You are only allowed to hit certain nails of a certain shape at a certain amount of only hit them a specific number of times, and only at a specific time of the day. And, well, actually, I don't know if there's a license for software that does that, but who knows. Anyway, you are not allowed to share the hammer with other people, and you're not imagine how stupid that would be. If in the real world, in the physical world, in the physical world, you use a physical tool like a hammer to hit nails, just imagine how stupid it would be, how ridiculous it would be if the copyright law thing applied to physical tools, and there would be similar proprietary licenses. Like, how stupid would that be? You would have to follow some sort of a terms of use license agreement on how to use your hammer. That's ridiculous. That's ridiculous. And I make the argument that it is equally as ridiculous for computer software also. People are just not as familiar with computers as they are with physical tools, so they don't understand that it's the same thing with computers. In case of computers, really, the software is the same as the physical hammer. Restricting what you are allowed to do with the software is as stupid as restricting what you are allowed to do with the hammer. It's basically the same thing. People just are not familiar with computers, so they just don't understand that there's a problem. Because computers are new, and people, for the most part, are not necessarily software engineers, so they don't understand how computers work and what is actually going on. They just see it as a black box that just does things, so they don't understand the problem. For the most part, for most people. But make no mistake, the problem is real, and it really is that stupid. Having a terms of use license agreement for your use of a hammer, what you are allowed to do with that hammer and how to use it, and you are not allowed to share it, and you are not allowed to do specific work with it. You are only allowed to... Yeah, but if you are only allowed to hit nails of a certain brand, you have to buy the nails from a specific shop that are made by a specific manufacturer. You are only allowed to hit those nails, and you can hit them only a specific number of times, and all that. Like, it's just stupid, ridiculous restrictions like that. That is so stupid. That is so fucking stupid. Sorry for the cursing. It wasn't my intention to do that in this speech. But just to emphasize that it's so stupid and ridiculous. But it's the same thing with the computer software. It is so stupid. You're not meant to... You shouldn't... No one should have the right to restrict what people can do with computer software in such a way. It is equally stupid for software as it is for the hammer. So that's why it's important to have a law, this third category that replaces copyright law, that allows the people to be free to control their computing and other practical works, whatever it may be, schematics and all this other stuff, blueprints, I don't know, whatever technical things people may do with like technical works that are used to do practical work or physical, or it doesn't matter if it's physical work or digital work. As long as it's work, you are doing things, you are like getting things done, you're doing work. So practical work, whether physical or digital, that work should be under your control. You should be the one who decides how to use a hammer, and you should be in total control of the hammer, basically. The absolute control over that hammer belongs to you, the user of the hammer. And the same should apply to software. You should be in control of the software. And to be in control of the software, it requires that you have the source code. Because if you have a proprietary software that doesn't give you the source code, you don't really control that software, you just get the software that you get. The difference between a computer software and a hammer is that computer software has a source code. A hammer doesn't have a source code. So there's no source code that should be given to the user because there is no source code at all. But in case of computer software, there is a source code. So the source code should be given to the user. See, here's the thing. If there was a source code to the hammer, if hammers had source code, it should be given to the people. I would implement a law that required the source code of a hammer to be given to the people who get that hammer. If there was a source code for a hammer, whatever that may be. But since there isn't any, then that's not a concern. That's not a thing people should think about, because unless in a specific context like this, thinking about things. But specifically making laws regarding the source code of a hammer isn't necessary, because there is no source code for a hammer, so that would be just nonsense. But it is useful to think about in this context of comparing things. One can imagine that if hammers did have source code, well, then it should be available. So thinking about this is useful in this context. Anyway, hammers don't have source code, so the hammer source code doesn't need to be made available. But computer software do have source code, and you need the source code to control the software. Otherwise, you don't really control it. You don't control it if you don't have the source code. With a hammer, you don't have a source code, so you don't need a source code to control it. You already control it in its current state because it doesn't have a source code. You just control it as is. But with computer software, there is the source code, and you need the source code to take full advantage of the software. Basically, it's this idea that you have to have the full advantage of it. You have to be in absolute full control. You have to have all the control you can have. With a hammer, you get the control by just physically owning it. Unless there are some bizarre laws that restrict what you are allowed to do with a hammer. That could be done. There could be a stupid law like that. But anyway, there is no source code, so that difference is important to understand. That they exist for the same purpose, and the same idea applies to both of them. The idea of being free to do whatever you want with it to the fullest extent possible. You should have the absolute maximum freedom possible. That's the idea. So with computer software, that requires that you have the source code to exercise freedom to the fullest extent. So that's a rather lengthy explanation, but I think it's important. I think it's really important, and that's the way it should be done. Is there a specific definition for what is software that respects the user's freedom? Well, yes, there happens to be. There are the 4 freedoms, starting from 0 and ending to number 3. The freedom 0 is to make use of the software for whatever purpose you want to use it for. In any way you wish, use your software to do whatever you want with it. The freedom number 1 is the freedom to study and change the source code. So the source code of the software, you can look at it and modify it, and you should modify it and to make it fit your need, basically. So you should have the freedom to do that. And then the number 2 freedom is you can copy the software and make exact copies available to distribution. So you can distribute the exact software as you received it to the people, anyone out there in the world. And then the third freedom is the freedom to distribute those modified versions that you made to everyone. And that's those actually I should restate that third freedom is the freedom to distribute modified versions in general. It doesn't have to be those specific modifications you made under freedom number 1. It can be any modifications for any purpose. You're just allowed to. The third freedom states that you are allowed to share modified versions. Yeah, it doesn't have to be related to the first rule. But the first rule is a prerequisite to the third rule, that you have the freedom to study and change the source code. Yeah, to fit your needs and all that stuff, but also to distribute modified versions. Anyway, the main reason the second and third number 2 and number 3 freedoms exist is mainly because of the current copyright law that states that like there has to be a distinction made between copying, making modified and unmodified versions, distributing them. I think that's good enough to retain. Well, really, under my ideal copyright law replacement legal system, in case of this third category, this third system of laws, remember again, I remind you that these are 3 different distinct sets of laws. They are not related, they are independent entirely, they are not branches of the same greater law. No, they are entirely different laws. I just remind you of that. So yeah, under this third category, this third system of laws, these third laws, the third category that replaces the copyright, under this law, those freedoms that I mentioned, they would be built into the law itself. Basically, that requires that all the software that is made has to publicize the source code. And in the case of other things that are not software, make the preferred form for modification available. And it's also a crucial difference to realize that it has to be made available, and specifically it should be made available along with the binary. So you are allowed to share binary-only versions if that's what the user wishes. If the user wants to download only the binary, you should be free to do that. You don't have to give the source code in that case if the user doesn't want it, specifically. But you have to make it available. You have to provide it optionally if the user wants it. So, in case the user wants the source code, you are obligated to give it to them. Basically, that's the idea. And in cases of software where there is only the source code, that is also a thing. Not all software is compiled to binary. Some source code is just used as is. They don't all get compiled into a binary. Well, in their case, they are already the source code, so you don't have to come up with any imaginary source code that doesn't exist beyond just the source code that already exists. So in those cases, there just is no binary, so you don't have to worry about anything. You just make the thing available, and then it's available. The software source code is the software itself in that case, so there are no binaries. Basically, the binaries are really indifferent to the laws. The laws actually don't concern binaries. Like, if I was to write the text of the law, I wouldn't mention any binaries. Actually, I might mention it. I might mention something like, in case of a binary-only distribution, or blah blah blah, yeah, blah blah blah, blah blah blah, yada yada yada. Anyway, in case something like that, I might write something like that, but really the binary is not a concern. The availability of the source code is the concern, or the preferred form for modification, I should say, because it's more universal. It covers the entire third category, not just computer software. So, yeah, the binary isn't the concern. Making the source code available, that's the important thing. as long as it's made available, then whatever other stuff you distribute isn't important. The software source code has to be made available. So if you distribute something else like a binary, well, that's just irrelevant. Who cares? But if you distribute a binary, you have to make the source code available with it. So in that case, the binary does matter. So long as there is a binary, you should make the source code available with it. So actually, it's not really irrelevant. It's just not the important thing. The binary is not the important thing, but it is still relevant. Yeah, it is still important, I guess, actually, in a way. But yeah, who cares? Actually, no, don't say it. I shouldn't say that. It is. I do care. It is important. But I'm really just arguing about, like, arguing. I'm really just explaining a semantics right now. Or actually, no, I'm not. I'm doing something else. Well, who cares? What to call it? What I'm doing? Who cares? Move on. Let's see. So, have I now covered all the things left to say? Well, I will say this. Oh yes, this is important. Yeah. I'm not done yet. The comparisons to the other categories and also things to say. Well, see, here's the thing. Let's compare to the artistic category, for example. Let's compare computer software. Well, no. Let's compare the third category to the first category of art. The third category of functional works to the first category of artistic works. Well, really? Well, there's one big difference, which is the giving credit part. Yes, that's something to. That's a big difference. That is a big difference. In the first artistic category, there is the requirement to give credit, and there is the conception of there's the concept of the original author and the exclusive monetary rights and all that. That's in the case of the third. No, that's in the case of the first artistic category. But the difference between the first and the third in this case would be that the difference between the first and the third on this issue is that the third category has none of that. The third category does not recognize an original author. The third category does not recognize any sort of exclusive monetary right or any other thing that is remotely relevant to, like, who is the original creator. There are no original creators. In the case of the third category of functional works, there is no such thing as the original creator. There's just software. And if you distribute software, you have to make the source code available. Yeah, so no matter who it is who's doing it, whether you personally wrote the software or whether you received it from someone else, the source code has to be made publicly available. So there's no recognition of someone who authored a software. There is no creator of a software. There's just software and people who distribute it and make modifications to it and distribute modified versions. So there is no recognition of an author. In case of the first and the second category, the arts and the politics, there is the recognition of a creator and the author's rights and their monetary exclusivities and credit having to be given. But none of that applies to the third category of computer software. There's none of that. There's no such thing. There's no such thing in the third category. Yeah. This is yet again a good example of how, like, each of these different categories that replaces copyright law as it currently exists in the world, USA and EU mainly, because those are the ones I'm familiar with. But it's mostly the same everywhere else, as far as I'm aware. But anyway, USA and EU mainly are the ones that I'm talking about as the current copyright law. Anyway, in the current copyright law, I already talked about this, how it is a stupid system. I called it a stupid system. Anyway, I already talked about this, but I'm gonna say something on it again. I'm gonna repeat a little. The copyright law really is bad because it's a single law that covers all these vastly different things. Artistic works, political works, and practical works. these 3 different categories that I made are very distinct. They are very different. They exist for different purposes. They do different things in the world. People use them for different things. They are entirely separate. They are different. They have nothing to do with each other, really. Copyright law as it currently exists is really stupid. It really is stupid because it covers all of these vastly different things, and it tries to implement this similar stupid framework that doesn't really make any sense, and it tries to cover too many different things. And it's just bad. It just creates problems, and it's also just evil. Yeah, it's just bad. Like, it's bad in every way. It's bad in moral, ethical way. It's evil, and it's just bad. It's just bad in a practical way too. It's just bad in every way. Like, there's nothing good to it. It's just bad. I would instead replace it with 3 distinct different laws. 3 different systems of laws that are entirely distinct. 3 different laws. Yeah. So I wouldn't replace copyright with a single law. No, I would just replace it with 3 different distinct laws that cover different things, different parts of lives and people's doings. Artistic work is very different from political statements of opinion and such. Even if there are edge cases like I talked about, well, those are edge cases. There will always be edge cases. There will always be things that kind of resemble like the other thing, and things in one category that kind of resembles the other category and things like that. But those are just edge cases. You just cut them off. You just set a rule and you say that, well, that's that thing and this is this thing. Yeah, and as long as you have like a good reason and you do that well, then it's good. It's all good. You know, you just have to put the difference somewhere. But for the most part, for the actual purposes, like, those edge cases really are very specific, and they are very, like, you are kind of making a very specific thing there. Like, yeah, like, also another one weird thing I want to mention just because I'm talking about it right now, and yeah, what about if you make computer software that's like kind of artistic in nature? It like has some sort of like a graphic visual effect going on. Like, you write computer software and it displays some sort of fancy graphics, and you could actually interpret that as like an artwork because, well, you wrote the code to display a visual. Like, the visual is the artwork and the code makes that art happen. So you could interpret that as an artistic thing. So yeah, there really are these sorts of edge cases where one category kind of bleeds into another. But that's no reason to put all of these things under the same law. That's just stupid. The same law shouldn't cover all of these 3 different categories. They are entirely different, despite having some edge cases that are kind of getting from one kind of resemble another category. But yeah, you just set a hard rule and say that one thing is the other and this isn't. So in case of those computer software, I'll just call them functional works, because, well, you gotta pick one, right? You gotta pick one, and it's much more easy and convenient, and it's consistent. The consistency is important, and also, like I already talked about, when you are implementing this law, it's important you set the definitions right there and then. Don't leave any of it up for interpretation. Don't allow any guesswork. It shouldn't be guessed at a later date. Oh, I wonder if this law applies to this. Oh, I wonder if that law applies to this. No. You just set a hard rule. This is this and this isn't. And in case some sort of a weird edge case does show up that has never been seen before, maybe technology advances and some new thing appears that the laws don't apply, they don't cover properly anymore. Well, I mean, you can always just change the laws, I guess. You can always just add new laws, change old laws, remove old laws entirely. You know, as the world changes, you just change the laws. You know, I'm not saying that like this form of doing things is necessarily the absolutely correct way to do forever. You know, if the world changes, you change your laws with it. That's how things work. But the way I see it is that for the current state of things, this is the optimal way to do what copyright law doesn't do well, and it should be replaced with to do better at than what the copyright law kind of does want to do but doesn't really want to do. Yeah, it's kind of a mess. The copyright law, like, I don't really know if it's like trying to do anything. Like, really, the copyright law itself just exists so that some people can just hoard all the resources for themselves, basically. Like, that's really just the purpose. It really doesn't exist to serve the people. It really just exists to serve the few at the expense of the people. Like, that's really the purpose of a copyright law. But like, sort of ideal conception of like what a copyright law should be, now that's what I'm doing here. Like, I'm doing like what a copyright law like system could be. That's what it could be. This is the correct way to do things. Yes. I'm pretty sure this is like if someone right now gave me the power, if I became some sort of a dictator of some country, yeah, this is the law I would implement. Like, basically, exactly like word to word for the most part, except for those parts where I was kind of like, oh, well, I guess it could be kind of like this, like the how far the derivative has to be in the first category to no longer be considered. Yeah, something like that has to be thought about. I'm not exactly sure on that. It's kind of hard to differentiate because, well, you can make the artwork like ever so slightly less original from as compared to the original copy. It really is a gradient. Like, it goes as a gradient. Less and less original you can make an artwork. It can be very close to the original, less close, even less close, even less close. Like, it can go into infinity and there is infinite precision. It's a gradient, basically. So what to do with a scenario like that, I'm not exactly sure yet. I guess I would need to think about that some. Is there some sort of a hard rule for at what point does the author of the original work no longer deserve any exclusive monetary rights? Yeah, it should be just decided. I should just pick some system, but it's important to pick it well. It has to be designed well to actually serve the people, because that's really the purpose of laws in general right now, isn't it? Isn't it right? That really is what the laws exist. That's really what. Yeah. Laws exist for the people. Indeed, it would be a mistake to think that laws exist for the few at the expense of everyone else. Now that may be the way things are done, and that may be the current purpose of the specific implementation. But the ideal way to do things, like how things ought to be, well, in that case, the laws do exist for the people. They should exist for the people. They should serve the common good and the betterment of everyone that the laws apply to, and whatever, like, which is everyone in a country, I guess, where the laws are implemented. Now, regardless, the point is that the laws, they exist, they should exist for the betterment of the people, for the common good. For the people, for the betterment, for the people's best interest, for the people's best interest. So, yes, that's really what laws exist for. So, the current copyright law, it doesn't exist for the people. It exists for the few to get more money from the people. That's the purpose. Whether it actually succeeds at that is a different thing. But that's like what the intended use of it is. But that's not the way things should be. That's not the ideal way that things should be done. Yes, I would eradicate the copyright law entirely. I would just get rid of it and replace it with these three different categories. So yeah, this exact law system, this is what I would implement. It would take some time to write down the specifics, the specific edge cases, and specific terms and all that stuff. That would take a while, I guess, to write all that specifically down. But I think this speech should get across the overview, the idea, the general idea. With this speech in mind, you should be kind of able to arrive to the same conclusion that I would probably come to, a similar conclusion anyway, if you intend to implement this law, that is. Now, of course, if you disagree with my views, then you're not going to do the same law, probably. That I would do, but let's say for the sake of this, that if you were to implement this law as I explained it in this speech, I mean 3 different laws, yeah, remember, 3 different distinct laws. This system of laws, yes. So if you intend to implement this system of laws, these 3 different laws, I think this speech should convey the message that I want to, and with this speech, you should be able to use this speech as a guide to get the idea across. Those sorts of specific edge cases, I don't know, would you, whoever you may be, decide differently on some edge cases, who knows. But the overall picture should look about the same, and yeah, this is the way I would do it, and this is the way I would recommend you want to do it. I don't know who you are, where you may be, but yeah, this is the law. This is the law that you should implement in case you have the opportunity to do so. And yeah, I advocate for it. Indeed, if you agree with my goal here, do share the speech, make it, give it to your friends. Now, because this speech would fall under the second category, in the spirit of following the law, the ideal law that you now wish to support, yeah, follow the law and follow the law suggestion, the proposal for a law, and share it with your friends and all that stuff. I'll do the part in publicizing the speech in the ways I want to publicize it, and you share it with your friends and whatever, I guess. But you can always share the links to whatever, like if I put this on the internet on some website, you can always share the links. Share the links so that people are driven to find my content on the place I put it in the place I put it in. Yes. So yeah, that's that. I think for this speech. Yeah. So wherever you are listening to this speech from, yeah, it doesn't matter really. You can share with your friends. You can either download this speech and share a copy of the file with your friends, or just share the links to the people. Yeah. That's good. So do share in that way. Share it, put the message out there. And also, of course, the ideas I speak of, they don't belong to me. So also, yeah, maybe I could get into that now that I talked about it. Well, I will add this to the second category of the politics and statements of opinion. No one can own the views, like the ideas that someone talks about. It's only the specific recording and the specific, like the recordings of some speeches. So in the second category, a recording that is made of someone's political statement, it is that recording that is under that where the law applies to. But if you make a version of that recording, you modify what they say, then that's bad. But if you yourself make a statement of your own views and they just align with those views, they are the same views basically, but it's your words, your voice speaking the words and all that, then it's your recording. So yeah, that's also important to emphasize, or rather mention, now that I'm mentioning it for the first time. So I'm not emphasizing it, I'm mentioning it for the first time. So yeah, that's important. I didn't mention it earlier. Yeah, it's worth mentioning that no one can own the ideas themselves. That would just be stupid. You cannot own a political view that like this way of doing things, some sort of like an economic theory, let's say. Let's say you come up with some economic theory. You can't own that economic theory. You can own a speech about that economic theory, but you can't own that economic theory. Anyone else can make their own speeches on that economic theory. The only thing you own, or rather have the exclusive rights to all the profits and all that stuff, basically the recognition of authorship that you would hold, the only thing you would get that for is that specific recording of you. So you don't get to own someone else's recording where they talk about the same topic, the same idea. So yeah, that's important because really, like, the ideas, they don't belong to anyone. Only the specific recordings can be restricted in some way, yeah. So if I state my view, you can make your own view with the same ideas. Like, basically, again, on you making something out of my speech, or whatever, you getting something out of my speech, if you wish to make your own speech, and you basically share my views, and you agree with all these points that I make, and you basically just repeat the same thing I said in your own words, and you just explain it yourself, well, that's your speech, that's your recording, and you get to publicize that however you want, and you get all the exclusive rights to that, and I get none of that, because it's your speech, your recording, and I'm not allowed to make a derivative version of that and publicize it somewhere. Yeah. Even if you say the exact same things, the same 3 categories and the same rules and laws and all that. So you can make the same exact speech, basically, in that sense. You talk about the same things, even in the same order, you can talk about all that same stuff, so long as it's your speech where you speak, like, your own voice and all that stuff. Because there's the distinction between making a modified version of an existing speech versus you making a new speech. Yeah, those are 2 different things. Edge cases should be decided on what counts as being from one category, what goes into one category and what goes into another category. Yeah, things like sampling might be difficult. If you take a sample of a political speech and then you use that in another work, is that sample still covered under the law of the second category? Because it is a part of a political speech, even if it is a really small sample, some sort of an audio segment, some sort of a part of the speech, like a really small segment of audio. That's really just like a small segment of audio, but it's still a part of that speech, so it's like still a derivative of that speech, kind of. There are difficult edge cases like that where you have to just decide how to do things. Like, you just have to decide, like, this is that and this isn't. Yeah, basically, it is kind of arbitrary. You just sort of decide what is one and what is not the other. Or maybe you just outright don't allow the use of political speeches as samples for music, let's say. Like, if you're making music and you want to use some politician's voice as a sample when they say some vowel, you just want to use that as a sample. Should that be allowed because it's technically a part of that speech? Well, I don't know, like, those are edge cases. You just have to decide. It's difficult, but it can be done. You just decide. Either you can outright ban that, just don't use political speeches as sources for your samples, or maybe there's some sort of a specific small limit that you can do, or maybe if you modify it to the point of not even resembling the original, if you just use it as a sound effect, like some sort of specific sound effect, it's not really a speech anymore. Like, if you take some politician's speech and you take some vowel sound out of their voice and you use that in your music, like, that's hardly a political speech anymore, so you're not really putting words into that politician's mouth or anything. That's really just a sample for music, so that kind of could be allowed, I guess, because, like, yeah, well, but at what point does it become a speech? If you include more and more samples, longer and longer takes, longer and longer clips of audio with entire words and sentences, perhaps, then at what point does it become a speech? Or, like, at what point would it qualify as being a derivative that isn't allowed under the second rule? Because remember, in the second rule, making derivative works, modified versions of the politician's speeches, or it doesn't have to be a politician, any person who has a statement of opinion. It doesn't have to be a politician, but I'm just using the politician as a placeholder term for that person who makes the recording or whatever, which again is a placeholder. The recording is a placeholder. It doesn't have to be an audio recording, it could be anything else. That's a political statement of some kind. Anyway, if you take those and you make a modified version, you're not allowed to do that. Remember, the second rule forbids that. Not the second rule. The second category, the law of second category, the second category law, it forbids making those modified versions. So what if you make music? At what point does it go from you making your own music with a sample from some political person's voice uses a sound effect? At what point does it go from that to being a derivative of that speech? Because, well, if it's just a really short clip of the audio, well, then that's just a random sound effect. But if you take a longer clip of the audio effect, longer clip from the politician's speech in the audio, then it's a longer clip and you could take entire sentences. What if it's music and there's like some sort of a background noise with some politician speaking their words and like it's on top of like this music like score, like some sort of background political speech? Like what if you do that? Is that a derivative of the political work? Well, who knows? Like, at some point you just have to make the distinction that this is not it and this is a political speech. Like, you just pick one. You just say that this is and this and it's arbitrary, but it still can be done, and you can do it properly. It can be done properly, yeah. It might be somewhat difficult, but it can be done. It absolutely can be done, yeah. Maybe you could allow all that music, because perhaps the listener of a music recognizes the fact that, well, it's not really someone's political view, it's just music, like with someone's political speech on the background, like, that's just music, These are just samples for the music, it's not someone's actual political statement. Perhaps the listener understands that it's not really that politician speaking their opinions, it's just music. So what if you make a parody where you take clips of some politician's speech and you put them together so that they say funny things and there's like some music? Would that no longer be a derivative of the politician's speech? What's the difference between a parody like that, where you just take clips from some politician's speech and make them say funny things? What's the difference between that and then taking some politician's speech and editing it in such a way as to make it appear as if they said something else and make it appear as a legit statement from that politician? What's the difference? That's really difficult. That's difficult to decide. That's hard to say. At what point does it go from being a silly artistic work to being some sort of a defamation campaign against some politician with some weird stuff? It's difficult to decide, but whatever, that's the real world. Gotta make compromises and decisions like that. But I think it can be done. It most certainly can be done. Perhaps some of it could be left for like case by case basis. Some judge could look at that and say that, well, this kind of looks like to me like it could be making like fun of the politician in like a silly way. That's fine. But like now this thing is just making the politicians say different things and pretending as if that's what they're actually saying. Some judge could decide that. Whatever. I guess some of it could be up for interpretation after all. Who knows? In case if it is really difficult to implement a specific law, then it could be up for interpretation. Some judge could decide it in some court case. Who cares? Well, it is important, so you should care. But like on the idea of having to say it specifically in the law, does it have to be specifically set in the law with hard rules where there's no room for interpretation? Is that necessary? Well, it's preferable, but if it can't be done, well, then I guess it just can't be done, and some judge is going to have to decide whether something is an audio sample used in a music, or is it a derivative of a political work? Because it's a gradient, it goes from one to the other, and you have to pick a point in that gradient where it goes from the other to the other, where it goes from one to the other. Anyway, that's enough for this speech. I've now explored all the things that are relevant, I think, and this is my proposal for replacing the copyright law. Get rid of copyright law and implement this system I just described in this almost 1.5 hour speech. Yeah, this is pretty good. Pretty long speech. Yeah. Pretty long speech. Yeah. I also gave a pretty good description of software freedom there in this speech. Yeah, that's it. That's pretty interesting. Yeah, actually that's pretty cool. Talking about the hammer thing. Yeah, I could use that to make a separate free software speech. Talk about the hammer analog. But whatever, I don't know. But that's not really related to speech anymore. Now I'm just talking nonsense. So it's better to end this here. So, thanks for listening. I hope this was somehow useful to you and you can advocate for some better copyright law replacements. Yeah, really just get rid of the copyright law as it exists and advocate for something like what I just described. I think that's a good idea. Because I'm pretty confident in my assessment of these things and this situation, and I'm pretty sure this is like a really good take on the issue. Yeah, I'm pretty confident on this. That I did this pretty well. I would say that if this law was to be implemented, it would work quite well. Yes. So, yeah, that's that for this bit. Thanks for listening. Until next time, bye.